not pleaded, I'd file a verified petition in the case.
Pleaded because it's a question, pure question of fact.
I agree.
Whether it is pleaded or not.
In fact, my lords,
If you make such a statement, we have to direct them to seek instructions.
that is what I'm saying in the very beginning. That is why I'm saying that. I've instructed this advocate on record to file at least a verified petition saying that it is not on the website. 1. 2, let him get instructions on that matter as the arguments are going on or for tomorrow. 2. Third, my lords, I just want to, in response to what your lordships just now said, in one judgment of their lordships, Justice Jeevan Reddy sitting with another judge in a matter relating to appointments. With regards to Himachal Pradesh or one of the states, they said, if there's an illegality that was so visible and not pleaded, even then we will examine it. But I understand that could be a case where it's a case of a recepsa locata without
if something is an admitted fact.
Yes, that's what I myself am conceding that aspect of the matter. So I'm putting them on caution to let them check up. I'll also file a verified petition saying that as on the date I am before your lordships, the GO is not available.
Which is the GO annexure?
GO 29 at page 178 of the book.
GO 29 is not under 309.
178.
Yes, sir.
It's not under 309.
This GO is not under 309.
That's not under 309. That's a.
They have amended some provisions.
Sir, GOMS 55.
And provision which is sought to be amended is GOMS 55.
55.
55 is an executive instruction
Yes.
or statutory?
Yes. One.
It is executive instruction or
Yes, sir. Executive instruction.
Page
You will get it at page 168.
168.
it's an executive instruction or
Yes,
statutory rule?
Executive
Executive
instruction.
instructions.
So where is the question of publication in the Gazette if it is an executive instruction? Mr. Senior Counsel, this GO appears to be an executive instruction, doesn't have any statutory backing.
It still would constitute a subordinate legislation.
There's no need of its publication. It's not under Article 30.
No, the Apex Court said any subordinate legislation, how and when it becomes effective, publication or promulgation must be made in a gazette.
But where is the need of publication of an executive instruction in Gazette?
If it's an amendment to something which is in the nature of any notification of the government must be through the gazette.
You're right, but the amendment is to page number 168. That is also.
But it should be through a publication in the
executive
gazette.
instruction. That is also not.
The reason is this. No, that may or may not be, but the problem is this. One of the pleadings that we have taken is that this was not in public domain for a long time. Anyway, let them continue their arguments. We'll deal.
Yes. We are only on the question of interim relief.
Yes.
Yes.
Milord, the two issues, Milord, which in fact raised.
What is the nature of selection?
Group 1 selections. Group 1 selections.
Group 1.
Group 1.
Yes.
In the state cabinet. Well, a notification is issued on 19/2/2024 for 563 posts.
Anybody prepared any synopsis? Anybody prepared any?
I've been already last year itself.
Synopsis. Any synopsis are there? It is heading is synopsis of WP 26038.
38, my lord. The lordship wanted last occasion about the GO, earlier GO, present GO, etc. That synopsis.
Yes, please.
Well, before that, my lord, just my lord, two issues.
Yes.
My lord, one is that, my lord, we are challenging, my lord, Rule 22, B, my lord, which is added through GMS number 96. My lord, stipulating the roster points to, my lord, in respect of the physically handicapped category. That, my lord, that rule is also challenged in this writ petition. That's the one issue. Second issue is, my lord, rule of reservation is not followed by issuing this GO. Amending earlier GO 55, your lordship knows this. These are two issues which are consideration for your lordship, kind consideration. One is that physically handicapped quota, my lord, your lordship knows, Rajkumar Daria, every principle of law, it has to be horizontally. But the rule has been amended.
Yes.
Rule 22 will also get at page 52.
That is at page
page 152. GMS number 96. This is made under Article 309 of the Constitution of India.
Yes.
Well, at bottom, set rules in Rule 22 in sub-rule 2. Well, the following shall be substituted, namely out of 50 appointments to be made on the basis of the open competition. Well, that I am not worried about it. Well, next, well, page 153. B, clause E proviso to following substituted. The 6th, 31st, 50th, 56th turn each of 100 vacancies, roster point, shall be allotted to the blind, low and so, shall be allotted. Intellectually disability, so and so, learning disability, mental, so and so allotted. In terms of the GMS number, so and so 38. Once it is horizontal, question of giving the roster points will not arise. Lordship notes, once it is a horizontal, the persons in the physically handicapped suppose with the meritorious. They will come up in the open. So this can't be roster points at all. And a notification, Your Lordship will get it. Page 4.1, notification, page 50.
Page
50.
50.
Yes, ma'am. 50. There will be reservations in direct recruitment in respect of scheduled tribes, scheduled castes, backward classes, and economically weaker sections. Persons with the disabilities, well, that is all shown as a vertical. And horizontal in respect of women and meritorious sports persons, so and so. But physically handicapped, reservations also is special reservation.
But how you are bifurcating it by reading 4.1 that this horizontal, they have mentioned horizontal.
Horizontal only for in respect of women and meritorious.
Yes.
Vertical reservation, that is a community wise, the Lordship will get the first limb of the provision.
Yes.
Well, this is against the principle of law decided by the first open, then the reservations of social categories. Thereafter, the rest of will be, even that also, if a physical handicap comes, he will be accommodated in the social categories only. After that, suppose any remain, that will go to them in a vertical about it, not this stage.
You are basically agreed about this handicapped persons, those who are not getting a reservation of their category.
What happened by giving the roster point, the 4% reservation, there are 24 posts have been earmarked for them. Merit people will come. Physical handicap people, merit, they will come. But in the vertical reservation, they will be fixed at the roster points. Had the merit people have been taken into consideration in open category, I would get more seats available for me to compete. So my second argument, I'll explain further about it. If it is taken as a horizontal, the more seats will available for other categories. If the physically handicapped will fall under the open category.
Yes.
And not only that, second limb of it, if this 4% is taken, it violates the 50% rule in the state. I think Rahul will agree that 29%, 15%, 10%, if it's taken, suppose 4% is added, it will go to 54%. So that goes beyond the 50% of the Balaji, Indrasani principle, etc. Therefore, keeping the physically handicapped roster points is illegal. I'll place one or two judgments, but Lordship kind consideration after my second issue. And the second issue is concerned with regard to not following the reservations. Issue is concerned with admission. Now the preliminary examination is held. Now the main examination, they have announced the website. In the website, what they have done is that 1:50 is the criteria as per the notification to call.
When main examination is scheduled?
21st, 21 to 27.
All tickets were issued to the candidates.
Now the second issue is that admission to those main examination without following reservation category wise is violated of Article 14 and 16.
Yes.
Without categorizing. Social reservations without, and only taking the merits into consideration for the purpose of main is illegal, violated of Article 14 and 16 of the Constitution of India. And if they segregated, the SC/BC category is open instead of open category. Here also, the reserved candidates will have a number of more candidates will come. Now what they have done is 1:50. They have announced website 192 about Lordship kindly see page 192. On the basis of the preliminary test,
Yes.
Page 192. On the basis of the preliminary test of so-and-so on 9/6/2024 for the post falling in the Group 1 service notified, the candidates with the following hall ticket numbers have been admitted to the written examination as per the criteria mentioned in the GOMS number 29, which is under challenge. I'll take that. That accordingly, this website, your Lordship will get a page 194, 31,000 some odd has been called. Your Lordship will get it page 194. 31,382.
Yes.
Your Lordship may come to GOS number incorporated here, but Your Lordship can come to the GO itself.
That is at
178.
page
178. This is in fact, this exam is the third time for the same post. In fact, earlier exam was conducted for the same Group 1 services twice for 503 posts. For some reasons, once for the manipulation, second, not following the biometric system, this Honorable Court cancelled those things. And thereafter this notification is issued. Now they added another 60 more posts and issued notification. Just before the notification, this GO has been amended. GO 55 has been amended. GO 55, Your Lordship will get it in 168. And those two notifications, they followed GO was 55. 168 emissions.
Yes.
And come to the GO, relevant GO portion is concerned, page 171. Pattern of examination.
Yes. Yes.
There will be preliminary test for the comprising of so-and-so. Test is meant for the shortlisting of the number of candidates to be admitted in the written main examination. The mark secured in the preliminary test will not be counted. Ranking in the preliminary test will be counted in English so-and-so. B is relevant, which I am affected by that. The number of candidates to be admitted. The number of candidates to be admitted in the written main examination, conventional side would be 50 times to the total number of vacancies available each multi-zone. This sentence goes for duly following the rule of reservation, community-wise, gender-wise, posts laid down as per the general rule 22(2)(a) of TS state and subordinate service.
Yes, sorry, we'll assemble after 10 minutes.
Yes.
Sorry for the interruption. Yes. We were at page
Page
170.
171.
Yes.
GMS number 55, I was reading with regard to how, they have preliminary examination, admission to the main examination, I was reading. 171B, the number of candidates to be admitted in the written main examination, conventional type would be 50 times of the total number of vacancies available in each multi-zone. Duly following the rule of reservation community. This sentence, Your Lordship, can you see? Rule of reservations for community 1.
Yes.
And gender EH, PH, SOTA laid down as per the general rules 22, 20 of subordinate service rules. Well, this GMS 55 followed in fact 2 examinations earlier held for the same post. And now, just before this notification, they amended this page 178. Page 2 they amended, notification issued on 19/2/2024. In fact, this, as a matter of fact, GMS 55 was also challenged before this Honorable Court in a writ petition. Writ petition bearing number, 20, bearing number 3048 of 2023.
Kindly repeat the number 30.
Writ petition number 3048 of 2023. State has defended saying that this is GMS 55 is the correct. In fact, the method which is following in other states, GMS number 570 is not correct. It is not appropriate for Telangana state under para 34 of the council. Now, having said so, the writ petition is pending. Just before this notification, they issued page 178. By deleting, that calling category wise reservation for the main admission, page 178 bottom.
Yes.
B, the number of candidates to be admitted in the written main examination convention would be 50 times to the total vacancies available in each multi-zone. That is also not followed, in fact, 192 page. This is the second sentence, provided that in case of shortfall in respect of candidates in reserved categories laid down in Rule 22, 22A Telangana State Subordinate, action shall be taken to include such a number of candidates on the merit list beyond 1:50 ratio as required, meet the shortfall. I'll read for this, subject to repetition, Your Lordship permit me to. Number of candidates to be admitted in the written examination would be 50 times the total number of vacancies available. Here, that reservation to be called category wise, community wise, has taken up. Now they are just calling, the very total for the preliminary examination, 30,000 they've called it. I already brought Your Lordship notice page 192, 194, 30,000 and odd. 1:50 on the merit basis they called it. They called it for admission, to write examination from October 21st onwards. Giving by reservation at all. Now, the contention is that whether, the reservation at the preliminary stage, main stage to be followed or not, what is the law on the subject? According to me, this I'm telling the amending is totally, first I submitted this is without any object, without anything, this is arbitrary, violative article 14 and 16 of the Constitution of India. Second is that the principle of law, right from Indra Sani and Balaji is that, if the vertical and the Your Lordship knows the scheme of the examination. First they take, the open, then, the category wise they go. Communal, then after, like that. Now by which what the principle of Indra Sani is that, the vertical and horizontal reservations are followed. Open and for the reservation categories, category wise, that will serve the public purpose of employment to all.
Yes.
That is the principle of the Indra Sani and other cases. And in fact, Your Lordship put it in one of the judgments while in Madhya Pradesh, saying that the object of implementing of that judgment is to, there is a purpose.
Have you checked whether that judgment was put to test before Supreme Court?
Yes, the Supreme Court has upheld it. I'll just take Your Lordship page. Your Lordship will just come to the page, Supreme Court judgment.
The judgment of Madhya Pradesh.
I'll read out judgment, Supreme Court judgment at page 278.
The judgment of Madhya Pradesh High Court.
Yes,
Not Madhya Pradesh, Your Lordship is not
Your
there.
Lordship's judgment.
Subsequently what happened, as per Your Lordship direction, again examination was conducted, again it was challenged, then matter went to the Supreme Court. The Supreme Court said, 2 paras, Your Lordship will just kindly take up at page 478. Well, before that, subject to your lordship permission, I'll take up your lordship para, one or two paras, then I'll take up the Supreme Court so that your lordship have a recollection of.
Page number?
470, your lordship judgment running, it started from 390 onwards. I'll take those two paras, then go to the Supreme Court. Page 470,
Yes.
Your lordship judgment. Ratio decision of Indra Sani is followed in R.K. Sabharwal, State of Punjab, 1995 to SCC 745. Recently, Saurav Yadav so and so. I would conclude by saying that reservations, both vertical, horizontal method, ensuring the representation in public service. This is the ratio of all the judgments. This is the principle called out. These are all the not received registrars for various candidates in the merit which otherwise entitled for to be shown in the open general category. Foreclosed consequences would be if state government argument is accepted. Doing so would result in communal reservation where each social, this is a principle, where each social category is confined within the extent of the reservation, thus negating the open category is open to all. The only condition for the candidate to be shown in the merit is regardless of whether reservation or the benefit. Finally, your lordship, come to page 45. Para 45, 475. The similar provision is the respondents could not assign any justifiable reason to establish rational purpose for bringing the impugned amendment dated 17/2/2020. Similarly, they could not establish the nexus between the object sought to be achieved and impugned amendments. Thus, impugned amendments dated 17/2/20 cannot be given stamp of approval, since it runs contrary to the binding precedent of Indra Sani followed by Saurav Yadav. The impugned judgment cannot be sustained judicial scrutiny by no imagination, withstanding of the 9 years of Supreme Court so and so. It was open to the government to amend the examination rules contrary to the principles laid down in Indra Sani under the garb of so and so. Division bench of this court so and so. We are of the considered view. This is a Miller, your lordship, that principle laid down in Supreme Court can be translated into reality only when reserved category candidate should be equal or more marks with the UR category candidate given birth in UR category in all stages of selection. This is an important sentence. Category in all stages of selection, including preliminary and main examination. This is the principle. And the other interpretation will defeat very purpose and the constitutional scheme flowing from the Article 14 and 16 of the Constitution of India. There is no justifiable reason for depriving meritorious. This is another facet of that argument. Meritorious reserved candidates who competed with the UR category candidates secured same or more marks than in being treated as UR candidate. The matter may be examined for other things. Your lordship struck down that Rule 4.3d of the Madhya Pradesh rules. Then the Supreme Court, your lordship, may come to very same batch. After your lordship direction, examination was held. Then they challenged. Then it was dismissed. When matter went to Supreme Court upheld. 478 come to 492.
No, this is arising out of this judgment or some other judgment?
Some other judgment, but same examination, same rules.
No.
After your lordship judgment, they followed the state of Madhya Pradesh. Then there was a challenge again.
Yes.
The same rule, your lordship will get it, page 492, bottom para 30.
Which para is relevant?
It was a batch. It was a batch. From the batch, one of the matters went up in appeal, and this judgment is against that.
Therefore, we are asking whether this is arising out of same judgment or
Yes.
But
Yes,
not
same
same.
Same judgment.
Your lordship, see, what are the principles, same rules? Page 30, para 30, your lordship. Page 490.
Page 490.
492.
Yes.
We may also note that Rule 4.3d, which your lordship struck down. Rule 25 patently harm the interests of reservation candidates, as even meritorious candidates from such a categories who had not availed any reservation benefit. Relaxations were to be treated with those reservations and categories, and they were not segregated. This is a Miller principle. Segregated with the meritorious unreserved category of candidates at the preliminary examination result stage. As a result, continue to occupy reservation category slots which would have been otherwise gone in deserving reservation candidates lower down in the merit list, that category. Had they been included with the meritorious unreserved candidates on the strength of their marks. Then, para 31, they have referred to Saurav Yadav, after the principle of the candidates belong to any of the vertical reservation categories would be entitled to selected open category. And if such a candidates belonging to the reservation candidate admitted entitled to select on the basis of their own merit, selection cannot be counted against the quota reserved for the categories of vertical reservation. That they belong to it was further observed that both vertical and horizontal methods are ensuring a representation to this is public services, and these are not seen as result slots, where a candidate merit which are not being seen result slots, otherwise entitled him to be shown as an open category, is foreclosed. Bench further observed that open category is open to all and only condition for the candidate is to be shown in its merit regardless of whether reservation benefit or either type was available here. This is more important. That this is being the settled position. It appears that state of Madhya Pradesh itself realized the harm that is doing to the reservation category candidates and choose to restore Rule 4 as it stood earlier, which enabled the drawing of the list. Preliminary examination, this is the method. Segregating the reserve meritorious reservation candidates with the meritorious unreserved candidates at the preliminary examination stage itself. As this process was undertaken after the judgment of Kishore Chaudhary, that's the Your Lordship judgment.
Kishore Chaudhary is the judgment which is authored by me.
You, yes,
Right. Now,
Your Lordship.
kindly come to para 33. Kishore Chaudhary was not put to test.
Not subject to challenge. But Your Lordship, Kishore said the Chaudhary case principle has been accepted by the Supreme Court. And the Supreme Court has said, it is to be segregated at this stage approved by the Supreme Court. Now, what's happening is that, Your Lordship, 1 to 30,000 people have been called. 30,000 reserved candidates are not being called. And what the proviso says, Your Lordship, just kindly come to me, Lord. Proviso says, if 30,000 if they called, if reserved candidates are not there, they will apply the proviso. By which they call again 1:50%. That's what the proviso says. Instead of right royal method, whereby open category, in this case, about 206.7.
What is the material today before us that the petitioners who are reserve category candidates secured more marks in preliminary examination than the general category candidates, and yet you have not been selected? What is the material before us?
No, one of the candidates.
Principle we have laid down, we are aware of it.
Yes.
But what is the factual basis for that?
In fact, the one of petitioner number 4 is successful candidate. The question is that, what's happening is
Can you show any example that a reserve category candidate secured more marks than a general category candidate, still could not secure berth?
At this stage, results, marks are not being announced, I cannot demonstrate.
Then this argument,
but Your Lordship, kindly see,
then this argument is premature, because unless you are in a position to show the breach of the principles laid down by us.
I'm come to that. Well, I'm saying that by calling 1:30,000 on the merits how they called. What they said, Your Lordship, is just take the counter so that it will be clear. Your Lordship, Your Lordship, kindly see. Just take them their counter, they file the counter. How they want to follow.
Who filed counter? State filed counter.
Public Service Commission is we filed counter.
State has not filed counter.
State, I represented Milord in the first instance itself.
Then you have filed or not counter?
No, Milord, state has. This is the PSC counters, Milord, which got returned for some reason.
When
Of the challenge to Wires of Disabilities Act. Not they are to agitate on the rule.
I'll come to that. I'll come to that.
We'll hear you. Without hearing you, we will not pass order.
Your Lordship, kindly see para 15 of your council.
Yes.
Para 15. It is humbly submitted that procedure for shortlisting of candidates for the preliminary main group examination service. Your Lordship, I come to next page 10. Elaborated in GMS number 29, maintain right of so and so balance for need for representation of each community category by adopting the following procedure. 1. Initially, the candidates are shortlisted at the ratio of 1:50, meeting the general standards level based on the overall merit. The candidates of all the communities, OCs, SC, SCs, are all in the list as per the merit. Well, first they admit will not entire on the basis of the merit list. Merit. Second, they say Roman 2. Among the list of candidates shows as listed, it is checked to 50%, which is to be called, then they go. Well, that is when putting the card before the heart.
One
The
thing is that both the instructions, GOs, which are under challenge before
This is
So
not,
they have-
this
they
is
have
not before the,
challenges.
yes, my lord, this is not before the learned single judge.
If they have challenged it, it will come before this bench only.
Yes, yes. My humble submission was, my lord, that under the guise of challenge of these rules, my lord, they brought in 29 also, which was subject there. My lord, it was never their intention to challenge the Disabilities Act, is my understanding. Because the lordships have seen,
The candidates,
See, whether their challenge to this page 152 will fail or not, we'll decide at
Yes.
appropriate stage. But
Yes.
till such time, the roster is with this bench only.
yes, yes,
So far other matters are concerned, you may file an application either before Honorable Chief Justice or before that bench for transferring this matter, because
True,
other things are also under challenge for linking those matters.
true, my lord, on last.
But this can't go to single bench.
No, no.
Yes.
To the extent of rule challenge, my lord, it is before your lordships, my lord. There is no dispute.
they are not giving the merits.
This will remain subject to, yes, that selection will remain subject to final outcome. But at present, very question of
The reason for that is-
Let me complete. I'll demonstrate one.
Therefore, to test it at this stage, on the ground that whether the petitioners are sufferers or not would be
Immaterial.
one. And the second aspect is we
As far as the petitions are concerned, 3 petitioners are SC, ST, BC, petitioner 1 to 3. 4th petitioner is the BC category. He, in fact, got into the main examination. When I just reading the candidates of all the communities, OCs, STs, so and so, are all in the list as per the merit. Next, Your Lordship, among the listed candidates shortlisted, means open category. Your Lordship, just kindly see. Open category. It is checked whether the candidates from each category, reserved category, also represented in the ratio 1:50. Will not 1:50 will not have reserved candidates will not as per the category wise entitled to be admitted in the main examination as per the notification. Because 1:50, Your Lordship reservation, whatever the category they fixed. I'll just, page 67 of my paper book, Your Lordship will know what are the reserved categories they have given along with the notification. Now they are not, community wise they have not called, open they called. What they are saying is under 2, 1:50 only will be maintained in respect of the reserved categories. Whereas open category candidates are getting number of more than that. More than that. Your Lordship, page 67 of my paper book, Your Lordship will just kindly take up, the categories may not like this will it will be filled up.
Yes.
Page 67 the bottom, Your Lordship may come to. Total vacancies. 209 for OCs.
563.
Yes, Lord. Total out of 563.
Yes.
209 for OC. 49 EWS. BCA 44. 37 BCB. BCC 13. 22. 16. 93. Then Millard. They call. Only 1:50. Well, let's suppose a meritorious candidate in the BC category, SC category, he's entitled to come in the open. Whereby what happened? Open candidates are getting an advantage. It would have been included